The first matter to come before the court is Roberts versus Falls Family Practice. As you know, each party will have 15 minutes to present oral argument. The appellant will proceed first and may reserve up to 5 minutes for rebuttal. We have read the briefs and we're ready to proceed when you are.
Fantastic. Thank you, Your Honor. May it please the court, my name is Tony Stukas. I, along with Barry Ward, represent the appellants, Danielle and Craig Daniels, who are with us here today. I reserve 4 minutes for rebuttal. There are 5 assignments in there, but I will address the first 2 together because they're related, and as it relates to what we believe should have been a direct verdict and instruction on the issue of patient negligence, that patient negligence was caused by one or both defendants, and that as a result, there should have been a verdict for plaintiff against one or both defendants. The basis of that is really reasonable minds, after looking at the evidence, can come to but one conclusion, and that is that Danielle Roberts was a victim of malpractice. All parties agreed, presented expert testimony, and there was expert testimony adduced at trial. And setting aside plaintiff's expert, which I want to talk about defense experts, Dr. Borison, who was hired on behalf of Dr. Hugh McLaughlin, appellee, to testify on his behalf. And he testified that he believed that Dr. McLaughlin met the standard of care. But he also testified to some very critical facts, and that is that he believed that Danielle Roberts had an anal fissure. And as a result, it was below the standard of care for Dr. Bender to have performed colostomy. That was his unequivocal, affirmative testimony at trial. He also testified that as a result of that breach of the standard of care, that Ms. Daniels underwent totally unnecessary procedures and surgeries, colostomy surgery, revision, reversal, and subsequent to that, because those surgeries took place in 2012, 2 years later, she ended up having another abdominal surgery to deal with adhesions that developed because of the previous surgeries done. All this being as a direct and proximate cause of the unnecessary colostomies. He moreover testified affirmatively that this was preventable. In other words, this didn't have to happen. All she needed was either a dilation and or a sphincterotomy to repair the fissure, and she would have been healed. Dr. Nichols, who testified for Dr. Bender, he testified, of course, that Dr. Bender met the standard of care, but he also gave affirmative testimony, unequivocal testimony, that Dr. Hugh McLaughlin instead breached the standard of care in performing the hemorrhoid surgery. He testified that he believed that what Dr. Bender encountered on her procedure when she examined intraoperatively, if you will, Mrs. Roberts, that she had thermal injury and damage to half of the anal canal, 1/2 of the anal canal, and that was below the standard of care, period. He further testified that as a direct and proximate cause of that breach, that Ms. Roberts, continued, needed colostomy surgeries, had ongoing problems, abdominal and rectal problems, had the subsequent surgery November 14 for adhesions, and required all the ongoing treatment. If we look at our expert, Dr. Prevey, which he testified consistently, Dr. McLaughlin breached the standard of care because he caused damage to half of the anal canal. And he also testified hypothetically that if it's true that she had a fissure and not damage to half the anal canal or thermal injury as Dr. Bender found, then he would say that Dr. Bender breached the standard of care. So he addressed that hypothetical. He also testified, and Dr. Borison testified, on a separate matter, that Dr. Bender had breached the standard of care in doing the original, in other words, the original colostomy, because she had mixed up the limbs of the, if you will, the intestine, therefore trapping the colon. It required her to go back for a revision. They both said that was below the standard of care. Putting aside the experts, when we look at what the party said, and that primarily Drs. Bender and Dr. McLaughlin, Dr. McLaughlin testified, although he was precluded from testifying to the ultimate issue, which we believe is error on a separate count, on the issue of negligence and breach of the standard of care, he testified unequivocally that all Mrs. Roberts had was a fissure, that as a result of that, she just needed to dilate it and remove some scar tissue, and she would have been fine. But instead, he said, quote unquote, that it was outrageous on the part of Dr. Bender to have taken this patient for colostomy when it was absolutely unnecessary, and that as a result of that, Ms. Roberts had to undergo a series of totally unnecessary surgeries and also treatment for her abdominal and rectal problems that she developed subsequent to that and were ongoing up until the point in time of 2014, because that was the last time he reviewed those records. And then lastly, we have Dr. Bender, who said, also was precluded from testifying to the ultimate issue of breach of the standard of care, which we believe is error. Setting that aside, she testified, look, this was a thermal injury. There was no doubt in her mind there was a thermal injury caused by Dr. Hugh McLaughlin during the hemorrhoid surgery, that the patient required all this care, all of the subsequent care that she referred her to, that is to university hospitals, Cleveland Clinic, University of Pittsburgh, and then ultimately she sought the care of Dr. Slazak, who Ms. Roberts was having for several years and ongoing and permanent treatment for her problems, all stemming from medical negligence.
Counsel, as I read the brief, I wondered initially whether or not the jury was unimpressed with the expert's testimony, because you have two doctors who were performing different procedures, and when you have experts coming in and kind of, one pointing the finger at the other, I wondered if it was a matter, if the verdict was as a result of either juror confusion or that the jurors were not convinced because of the finger pointing. But what I had no idea until I read the appellee's brief about the claims of your client taking the narcotics that caused, as appellee is suggesting, that caused constipation. But that was not addressed at all, and so it was a little perplexing.
And then let me address a couple issues here, Your Honor, and I appreciate your raising those. First, as it relates to jury confusion, it may be that the jury was confused, and that is why the trial court had a duty to make it very clear to the jury in terms of what the status of the evidence was, and they should have been instructed specifically as to what was being found by the court and what their duty was in determining this case. The court had an obligation, based on the status of the evidence, that this patient was a victim of medical malpractice, period. And their job would have been to determine who, because the only persons that there was testimony provided at trial was either one defendant or the other, or both. On the next point, in terms of perhaps unimpressed, well, I can't speak to whether they're unimpressed or not. I think they were confused, but ultimately, assuming for the discussion that they were unimpressed, this is not a situation. It really goes to Applee's argument that, well, they have the right to believe all, some or none of somebody's testimony and credibility and all, and that's true. However, the difference is that when you have all parties agreeing to a certain point and a certain fact, then I think it takes it out of the jury's hands. When the parties agree, it has the same effect as a stipulation. And this is why the court should have taken that opportunity to have removed that issue from the jury's hands and to simplify this case for the jury, and rather than make it more complicated. That was the duty of the trial court. Lastly, in terms of the pain medications, and I'll tell you, and I'll be candid, that was a designed argument to simply, without any basis, to paint the plaintiff as a bad person, to make suggestions that she was a narcotic abuser, that she was actively seeking narcotics, okay, so that the jury wouldn't like her. And it was essentially a design argument, if you will, to entice the jury to have some bias or prejudice against the patient who takes pain medications that was prescribed by her physicians, by the way, legally, okay, and put her in a bad light so that they would decide this case on prejudice or bias, rather on the evidence that was submitted to court at a trial.
I can appreciate your argument,
That's the way I believe it came across at trial, but let me address that specifically. Some, as it regards to a narcotic abuser, okay, or that she was abusing pain medications or over-medicating. Dr. Borison, defense expert, testified that he did not come to that conclusion. Dr. Bender testified that that was not the case, that she was a compliant patient. Dr. Nichols testified for Dr. Bender, another defense expert, said that there was no evidence, any evidence of narcotic abuse. This was all made up and fabricated by defense counsel.
Well, if we step away just for a moment from narcotics abuse, what I think we may be left with is the impact of taking those pills
And it's,
on your digestive system. And you're right at the 4-minute mark, so we'll answer that and then.
and address that is, look, this case boils down to whether there was a fissure or whether there was damage to half of the anal canal, thermal injury. Okay? The pain medication, narcotics, if it resulted in constipation and then resulted in a fissure, that's fine. I mean, we'll accept that because that's what narcotics can do, cause constipation, and can result in a fissure. But the claimed injury in this case was not a fissure. The claimed injury was the totally unnecessary procedures and surgeries that she either had or had to undergo, depending upon the status of the damage to her anal canal. Thermal injury and half of the anal canal damage that was testified to by Drs. Preby, Bender, Drs. Nichols, that could not be caused by constipation, unless, to quote Dr. Nichols, is that unless she was eating broken glass. So that takes that out of the issue. If it was a fissure due to constipation, due to narcotics, then it's not the fissure that we're claiming was the harm, it was then Dr. Bender's negligence and then taking her and doing all these unnecessary procedures that would not have been the standard of care treatment for a fissure. Fissure only required dilation, maybe a sphincterotomy, and she would have been healed. That's why the fissure issue, whether narcotics led to it or not, is a non-issue because it bears no relationship to the damages claimed by the plaintiff. Thank you.
May it please the court, good morning. I'm Michael Kalenberg. I represent Dr. McLaughlin and Falls Family Practice. Stacy Delgros, to my right, also represents Dr. Bender, and we have agreed that I will have 10 minutes and she will have 5 as I conclude. I had a couple prepared remarks, but I think maybe it makes more sense just to jump to the dialogue that is just occurring. To the first assignment of error, that the plaintiffs believe that a verdict should have been directed in their favor as to someone was negligent. The exchange that we just heard was that if Dr. McLaughlin was negligent, the injury that he caused was a thermal burn, if that happened. However, if Dr. Bender was negligent, the injury that she caused was an unnecessary procedure and allegedly not properly performed and required a revision and ultimately takedown of some adhesions. Those are not indivisible injuries, and we cannot sit here and say, under the law, that one or both of them is liable. The injury is some amount, some harm, and it should just be up to the jury to determine what percentage each physician bears for that injury. If Dr. McLaughlin did not cause a burn in this case, which we believe the evidence fully supported that at trial, then having the court direct a verdict that says 1, 2, or both of the defendants are negligent, you just have to figure out, jury, who and how much, and then we'll assess the damage against them. But if Dr. McLaughlin didn't cause any injury, then it wouldn't make sense that the court direct a verdict that potentially subjects him to liability, only allowing the issues of proximate cause and damages to be decided. The same is true for Dr. Bender. If there actually were a burn, and if there had been, and if there was a necessary colostomy to be performed, she didn't cause any harm, she didn't do any damage, but they're two different injuries. It's not as though we're talking about a car accident where two cars come together, one person hits their head on the windshield, and then it simply is up to a jury to decide which driver caused the injury. These are two separate injuries occurring weeks apart that do not have the same proximate relationship to each other. So with that respect, I don't believe that a directed verdict would have been appropriate. In fact, from the defense position, That would have been reversible error in itself. It would have removed the ability of two medical defendants who both were fully supported on duty, breach, and proximate cause and damages at trial with expert testimony. They both had that fully supported. And to strip that away from them and just leave them to have to answer for damages and fault apportionment, that would have been error. The trial court got this correct, that there's no way that a verdict could have been directed to find that one of them or both of them were negligent. They're two separate injuries. And with the expert testimony in hand, there was no other result the court could have had on that issue. And I guess that ties into something that Attorney Cerujas said earlier, that all parties agreed as to some injury occurring. We don't agree. It was not an indivisible injury. There were separate events and separate harms that were caused. Getting to another point that was raised by Attorney Cerujas is the issue of the patient negligence, and this is to their second assignment of error. The patient negligence instruction is not just geared towards the fact that the plaintiff may have taken too many of the narcotics that were prescribed for her. There's another component to that instruction, which is that during the course of taking what Dr. McLaughlin described, even his prescribed amounts, that's a massive amount of pain medications. It's appropriate, but it's a lot. 3 a day is a lot. But in order to take that type of medication, you need to stay on stool softeners and you need to continue laxatives. If you do not, the result is pretty obvious for anyone who's ever had to take these types of medications, is you will become constipated, you will have hard stool. Passing hard stool causes straining, it can cause tearing in the anal canal. That's a fissure. Once you develop that fissure, if you continue to take these pain medications and you continue to discontinue the use of stool softeners and laxatives, that moderate fissure can become a chronic fissure, which ties back into the underlying issue in the first assignment of error. A chronic fissure, the testimony at trial, is a chronic fissure can appear similar to a burn. And I do not believe, based upon my review of the record, that there was ever testimony that the mistake of a chronic fissure over a thermal injury is actually a deviation from the standard of care. They're quite similar. And so in that respect, although I'm not representing Dr. Bender, I don't believe that there was even evidence with respect to, because she chose colostomy, if it were in fact a fissure, that in itself was a breach. Or if there was, it was still supported by her experts at trial. So either way, there's competent, credible evidence in the record to support the defense of the case. A couple issues that weren't really addressed, but I wanted to raise because they are assignments of errors that have been raised by the defense, or their third and fourth assignments of error with respect to expert testimony that was not allowed by the trial court with respect to Dr. Bender and with respect to Dr. McLaughlin. The issue here, with respect to the testimony that was to be offered by Dr. Bender, it is not that the trial court was even considering an issue of qualifications, although that's a separate issue under Rule 702B that the court could have considered to opine critically against Dr. McLaughlin. But the other issue is, when Dr. Bender was deposed in this case, she said that she could not say whether Dr. McLaughlin had breached the standard of care. Based on that expert testimony, when we showed up at trial and those questions were posed to her, it was an attempt to elicit a not previously revealed expert opinion the day of trial. And that, in and of itself, would have been surprise evidence and error in its own right. So before we even get to the fact that Dr. Bender was not qualified to offer an opinion regarding the performance of a hemorrhoidectomy with a CO2 laser, she also should have been appropriately precluded from offering any opinion to that respect, because in discovery she did not reveal that opinion upon a direct examination during her deposition. To the flip side of
But
that,
I take it that conversation never came up in the record.
so there
On
was
that
the testimony of Dr. Bender with respect to whether Dr. McLaughlin breached the standard of care. Her deposition is of record. In the record, it was filed, and the answer to that question, which is cited in our brief, as she indicated, I can't really answer that question. That was her response, and that was the conclusion of whether or not she had an opinion as to whether the standard of care was breached. And it did not come up at trial based upon the court's rulings on that direct issue.
But the issue that came up was the court limiting her testimony based on her not having claimed expertise in a particular area.
Correct. Under either scenario, it was a correct exclusion of that testimony. Dr. Bender testified that she does not perform these procedures. She's not a family practice physician. She's a general surgeon. And there was no testimony established and developed in the record that demonstrated that the two physician subspecialties are substantially similar, or there is substantial overlap as required under Ohio law in order to allow one subspecialty to testify against another subspecialty. And the same holds true for Dr. McLaughlin with respect to the testimony that was attempted to be elicited from him criticizing Dr. Bender. Dr. McLaughlin testified that with respect to these types of patients, if in fact they needed to have a diverting colostomy, he's never done one, he's not qualified to do one, and he would send them out for a referral to someone who could do one. So again, with respect to the third and fourth assignments of error, the trial court was absolutely correct to prevent these physicians from different subspecialties to actually point the finger at each other. In fact, they didn't point the finger at each other at trial. And that gets me to the last case that we cited, or the important case that we cited in our appellate brief.
And go down to 1 minute.
Thank you. And that case is it's the Rothaker case coming out of the 5th District. And in that case, the case involved a commercial fire that was set, where it was alleged that two different parties were responsible for causing this commercial fire. At trial, the defendants absolutely pointed the finger at each other. One said, "You caused it," the other said, "You caused it." The plaintiff asked for an instruction saying that, you need to just determine, the jury should just have to determine who is at fault by a fault apportionment and damages. The court denied that motion by the plaintiff, and the jury returned a verdict in favor of both defendants. And as the 5th District noted in that case, the jury was absolutely entitled to believe some of the defendant's experts, some of the other co-defendants' experts. They were entitled to believe some of the fact testimony of one defendant versus the fact testimony of another. They could have believed it or rejected it all. And in that case, they chose to reject the claims asserted against both defendants. And that's absolutely within the province of the jury.
And you reached your...
Thank you. We would ask that the court affirm the trial court's entry on the verdict below. Thank you.
Good morning. My name is Stacy Delrose, and I have represented Dr. Elizabeth Bender during the entirety of this case, both the trial, and I am here today to represent her as well. I'm not sure I can improve upon the arguments by my co-defendants' counsel. I'm happy to answer any questions that the court has, but I would like to point out one thing with respect to the issue of directed verdict jury instruction. If the court carefully reviews the transcript, the plaintiff never moved for directed verdict. Instead, the plaintiff asked for a specific jury instruction. There is no motion for directed verdict on this record. I point that out as a procedural matter, but the essence of the issue is the same. The plaintiff wanted the court to instruct the jury, essentially, you have to find someone is responsible for this injury.
Did the court treat it as a motion for...
The court did not treat it as a motion for directed verdict. The court denied the request for a jury instruction. That's pretty clear from the record. In either case, the effect would be the same, essentially, taking that issue from the province of the jury. There were a lot of hypothetical questions asked of every single expert witness. If Mrs. Roberts sustained a simple anal fissure, was it appropriate to do a colostomy? What is your answer to that question? The surgeon said, if it is a simple anal fissure, then it's not appropriate to do a colostomy. However, if it is something other than or more severe than a simple anal fissure, a colostomy is appropriate. Dr. Borison said that, Dr. Prevey said that. If Dr. Bender encountered a significant injury of whatever nature that she determined it was best for Mrs. Roberts to have a colostomy, she met the standard of care. Dr. Borison said that, Dr. Prevey said that. One thing that Mr. Zeruhas didn't point out in his argument, because it's not in his best interest to do so, is that the plaintiff never hired an expert to criticize Dr. Bender. She was not a party to this case until Dr. McLaughlin raised issues in his deposition. Even after Dr. McLaughlin raised those issues, the plaintiff didn't get an expert to criticize Dr. Bender. And Dr. Prevey, their own expert, said, I believe Dr. Bender, the only person who actually saw the injury, I believe her description, and it was sufficient for her to perform a colostomy. The plaintiff's own expert. So to instruct the jury that they must find that either Dr. McLaughlin or Dr. Bender was negligent, you figure out which, that would be highly inappropriate.
What about the fact, though, that the initial colostomy was corrected, it was not connected correctly?
Well, Dr. Nichols, Dr. Bender's expert, addressed that issue. It's an unfortunate complication of this kind of procedure, even when done appropriately, because of the way that procedure is performed by externalizing the two ends of the bowel. So you can do the procedure technically correctly and not know that you've hooked up the wrong ends. So he supported Dr. Bender's care in that respect as a known complication.
Expert testimony that it was not below the
Correct.
standard of care.
Correct. So there's ample evidence in this record to support a verdict in favor of Dr. Bender, as there's ample evidence in this record to support a verdict in favor of Dr. McLaughlin. As the court has noted, and as counsel has noted, the jury had the right to accept, reject, all, some, none of the testimony. It was the plaintiff's burden to convince this jury that one or both of these doctors were negligent. And the jury in this case rejected their efforts to do so, obviously, because they found in favor of the defendants. And that was in their province to do so. What Mr. Zarujas is encouraging in this case is, I guess, a general rule that if there is finger pointing amongst defendants, there has to be a directed verdict in every single case. And that's just not the law in the state of Ohio. And just briefly, I wanted to address the issue of the expert testimony by the defendants.
You have 1 minute remaining.
In essence, if the court carefully reads the testimony that occurred in trial, they were permitted, both Dr. Bender and Dr. McLaughlin, were permitted to go right up to that line. In fact, Dr. McLaughlin, who is clearly not qualified to comment on standard of care for a surgeon, said the care was outrageous and unnecessary by Dr. Bender. I mean, that information got to the jury. The jury knew he didn't like what Dr. Bender did. Dr. Bender was a little more reserved, as is her personality. She was asked, if there was a thermal injury as you described it, can that injury occur when the operator does everything right? And she said, I don't know how this injury can occur without negligence. So they got right up to that line, right there. So the harm by not being able to answer that specific, did he violate the standard of care, did she violate the standard of care, harmless. Was that?
And that's the end of it.
Thank you.
Counsel, you have 3 minutes.
Thank you, Your Honor. In addressing the issues of Drs. McLaughlin and Bender and their opinions, Dr. McLaughlin had already offered a standard of care opinion in his position, recited the page and line number, and it was also filed with the court. This was not a new opinion. And he said specifically it was a breach of the standard of care. There's something about that language because it addresses the ultimate issue of the element of plaintiff's claim. And the jury is entitled to hear that from the party directly because it carries great weight in terms of what the party thinks as well, not only the party's witnesses. That's number one. Number two, he was more than qualified. Dr. McLaughlin testified that he treats fissures in his practice regularly. He knows how it's treated. He testified that a colostomy is not indicated for a fissure, and it was unnecessary, and the only question left to ask is it a breach in his standard of care? He would have said yes. The court improperly precluded that opinion. He was qualified because he treats it, he has treated it many times, and he knows what the treatment options are. He does not know how to do the surgery. I was not asking about how the surgery was done. As it relates to Dr. Bender, she testified in her deposition, much like Ms. Delgros was representing you, that number one, how does this injury occur? And she said that this is a complication, quote unquote, this is a complication that occurs when the equipment is used incorrectly or improperly. Next question, is that a breach of the standard of care to use equipment improperly? Yes, unequivocally, yes. The only question left, therefore, in this case, do you believe that then Dr. McLaughlin used the equipment improperly and breached the standard of care? That she was precluded from offering that opinion. She was asked about improperly used equipment in her deposition. It's not my witness. This is not my expert where I'm showing new opinions. This is a defendant. The jury is entitled to hear what this defendant thinks. They could have asked the question of her in her deposition, They could have cross-examined her. They chose not to. I didn't know what the answer was gonna be, but I think we all know here pretty certainly that the answer was gonna be yes, it's a breach of standard of care because the foundation had been laid unequivocally, and that's where the answer was going, and that's why he objected, and the court then improperly excluded it. The question, and I wanna make sure that this issue is addressed, and there was a representation made here that, Dr. Borson said that, a bad fissure can look like a burn. Okay, sure, he suggested that. But ultimately, his opinions, both Nichols and Dr. Borson, defense experts in this case, were not prefaced, if this, then that. Would you agree? No. When you look at the transcript closely, is it your opinion that Dr. Bender breached the standard of care? Yes. He didn't say, he could have said, oh no, I can't say that because it may have been a fissure looking at. No, that was not the testimony. The testimony, the parameters, and the box that we were in, the boundaries that have been established, it was either a fissure or it was extensive damage to the anal canal. There was nothing in between.
And you've reached the end of your time.
Thank you, Your Honor. We respectfully request the court reverse and remand this matter for a new trial. Thank you.
Thank you, all parties, counsel, for your presentation. The court will take the matter under advisement. We will issue a ruling which will be sent to all parties, and do check the Supreme Court website and our website as we post our decisions. Thank you.